Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to finish off the saga of the Queen and Senior. Although I say finish off, but there's actually part of this yet to come because there's going to be another hearing on entrapment issues that we'll cover later. Now, if you haven't watched the previous videos, they're quite lengthy. If you enjoy this, you might want to go back and look at those, but I'll give a brief recap here. Constable Senior, they suspected that he was misusing computer systems, and so to investigate this, they paired him with a new partner, and that new partner was actually an undercover police officer. They also wired up his vehicle, both his work vehicle and his personal vehicle, to be listening devices. They were full of surveillance equipment, as well as his cell phone. They also got him to meet this informant who was basically playing the role of a mid-level organized crime figure, and this informant was another undercover police officer. Now, this informant was giving them information that was now becoming sort of the focus of Constable Senior's career because he kept getting told, hey, you're doing all of this great work. Look at all this stuff we're seizing because of you. So he's kind of dependent on this. They're also getting him to break the standard undercover protocols because normally you'd meet with one of these informants with two people, but his partner keeps blowing him off and sort of getting him to meet with this, drug figure on his own because they're trying to get him sort of snared in. Now, all of this kind of comes to a head as they eventually come up with this plan where they're going to rip off drug dealers on their own, and there's a theft of a shotgun that comes to bear. So that, I think, is sort of enough background. We'll also see some of the facts as we go. I'm going to try to keep this sort of brief just so that we can look at the law, because this is a really interesting case for the analysis with respect to a whole bunch of different counts. And just because the judge convicts on one count doesn't mean he's going to convict on another. He's being careful to analyze each in turn. So let's dive into the case and have a look. So we've gotten as far as drug warehouse, count 6, possessing a firearm obtained by crime, count 7, possession of weapons for purpose dangerous to the public peace, count 8, attempted robbery, and count 9, trafficking cocaine by officer. So they say on July 12th, 2018, just before 3 p.m., Constable Senior and UC1, that's his fake partner, met Henry, who is, again, the fake informant, playing the role of a mid-level Asian organized crime figure in the course of a staged traffic stop. Henry offered them information on storage units containing drugs, guns, and cash in exchange for not being given tickets. During the interaction, as instructed by his handler, Henry gravitated toward Constable Senior in that he stated, "You, Richard, I want to deal with you because you look like someone I can trust." Sometimes you read these things and you just kind of wonder how people get suckered in by them, but when you're in the moment, it's not going to be as obvious. But, this guy wants to get out of traffic tickets and he's going to give you, storage lockers full of drugs, and he immediately gravitates to you as, it's got to feel like Christmas. But if something feels too good to be true, maybe it is. All right, we're going to skip over a fair bit here just because I want to keep this as brief as I can. So I'm trying to cover sort of the critical bits here. On September 12, 2018, Constable Senior told UC1 that Henry would now be providing warehouses rather than lockers, and they talked about Henry up in the game. UC1 stated, "An effing warehouse is an effing huge score. A shitload of cash coming in out of those effing places, man, you know what I mean." UC1 stated that he was curious to see what the warehouse was all about. Constable Senior agreed that there was a lot of cash, but they were just the intel guys. "We don't do the doors, we don't get hands-on." UC1 stated, "Why not?" UC1 stated, "But I'm looking at a big score, so F it." Constable Senior stated that he did not think it was any time soon, but rather than a couple of weeks. UC1 then stated, "If it's that much of a warehouse, if it's that much effing dope, I don't care about the dope cash and stuff. Why don't we just effing, I got a pair of effing snips. You know where I'm going with that." Constable Senior laughed, and the conversation then went in another direction. So you can see that his partner, UC1 here, is basically kind of feeding him the idea of we could raid this place. Now you might be wondering why I'm using effing when the text has the actual words. Well, I don't want to tick YouTube off. That's just the nature of the game. they get upset about profanity. So we're going to keep this at a lower age level here. Skipping ahead. On September 17th, 2018, Constable Senior and UC1 met for breakfast. After breakfast, Constable Senior stated that Henry was going to be out of town for a few days, but get your pry bar ready. Back at the station, UC1 inquired about the warehouse, and Constable Senior said that he did not know when the information would be coming, but that he just said it's something big coming. UC1 inquired, "What do you want to do with warehouse?" To which Constable Senior said, "I don't know. What do you want to do?" This went back and forth to where Constable Senior said, "You want to make some money?" To which UC1 said, "F yeah. What do you think? Why not?" Constable Senior then said, "Well, here's what I'm thinking. My logic here, I say we tell what's-his-face, like he tells us where it is, we have his guys knock it, we take the cash and he takes the product, and done." UC1 expressed concern about having Henry's people knock it, because of course he's trying to get Constable Senior in deeper. It's kind of interesting. I mean, both ends of this transaction are undercover cops, so Henry can behave in ways that are convenient for this whole plan to go down. Meanwhile, UC1 is going to sort of feed him ideas and then back away from those ideas in order to make Constable Senior take a step himself. So Constable Senior then suggested a combination knock. His guys take the product and go, we take the cash and go. UC1 suggested the need for a person to keep 6, which was then discussed, in addition to the fact that neither of them had any interest in holding on to the drugs. The discussion continued about how to best knock the warehouse, including someone to take the product if Henry was not involved, and what to do if there was a safe, finding a person to keep 6, and needing a van. On September 18th, 2018, Constable Senior and UC1 refined various aspects of their operational plan. They discussed the need for a person to keep 6, cameras, whether they should all wear black, no phones or personal cars, use of a rental van, casing the warehouse, going in clean or heavy, reference to firearms, having a bullshit warrant, the need for zip ties and rubber gloves, where to take the product, the cost of cocaine, and to whom and at what price to unload it. They described this as version 1.0. On September 19th, 2018, Constable Senior and UC1 discussed the warehouse plan, including a person to offload the drugs to and a price, silly string for the cameras, shopping for clothes and shoes, an escape plan, the need to bring duffel/gym bags, firearms, and surveillance. They referred to this as version 2.0. Later that day, while doing foot patrol at the mall, there was further discussion about the plan, including the use of a drone, supplies they would need, and going to the Walmart shopping. This was referred to as final version 3.0. It's good that they've got version control for all the computer geeks out there. On September 24th, 2018, Constable Senior and UC1 again discussed the warehouse plan. Constable Senior referred to it as an uphill battle and that they would need to redo everything, even if we decide to greenlight it. Constable Senior then advised UC1 what he'd been told by Henry. Constable Senior stated that he had discussed a price of $32,000 per kilogram with Henry if he would take the drugs. Among other things, Constable Senior suggested going in way heavier. Constable Senior suggested providing the information to Detective Sergeant Bedford, but then referred to it as a big score, so he's kind of waffling here. Constable Senior suggested taking shotguns or assault rifles from the station. They don't mean assault rifles, they mean AR-15s, but it is what it is. They talked about using a code word, how to get into the unit, and the possibility of using a RAM from work. They referred to this as version 4.0. Constable Senior went to Home Depot on September 28, 2018, and made 2 separate purchases. The first, paid with a debit card, was for general household items. The second, paid with cash, was for duct tape and zip ties. All of which seems like terrible operational security there, but moving on. On October 1st, 2018, Constable Senior gave UC1 a Home Depot bag containing duct tape, zip ties, and syringes. UC1 put the bag in his car. They talked about further details of the warehouse plan. The officers took handfuls of gloves from 5-core and put them in property bags to differentiate size. They discussed wearing vests or raid jackets. UC1 left the station with a duffel bag containing the rubber gloves and Constable Senior's police vest. On Thursday, October 4th, Constable Senior and Henry, Detective Salia, had a text message exchange about the quantity and origin of the cocaine in the warehouse. Now, Detective Salia is not the usual guy. He's a stand-in. He's I guess the usual guy must have been on vacation, so this guy's answering the cell phone. So, quantity and origin of the cocaine in the warehouse and the anticipated timing. Henry stated, "The spot will be ready to go Tuesday or Wednesday at the latest, brother. We can arrange a pickup for sure on Tuesday or Wednesday. I considered what you said, and like I said to you, I never turn down a good business opportunity. I'll give you 28 per box, and take them all from you, brah." Constable Senior stated that they're looking for something along 32 a box, to which Henry then agreed to 30,000 a kilogram, and Constable Senior said he would ask. On October 6, 2018, Constable Senior texted Henry and said they agreed at that number, 30 a box, and agreed that if there were 15 to 10 or 5 to 10 kilograms in the warehouse, Henry could buy all of it. That's a lot of money. On Tuesday, October 9th, 2018, UC1 and Constable Senior met in the parking lot of the LA Fitness where the rental van was parked. Constable Senior unlocked the shotgun from the YRP Tahoe, that's the police Tahoe, using the keypad mechanism, and placed it in the back of the rental van. UC1 covered it with a blanket and locked the van. They then left the area and returned to other police duties. So the law in relation to possessing a firearm obtained by crime. In order to find Constable Senior guilty of possessing a firearm obtained by crime, this court must be satisfied of the following essential elements beyond reasonable doubt. So first, that Constable Senior was in possession of a firearm. Can't be committing the offense of possession of firearm obtained by crime if you don't possess it. Next, that the firearm was obtained by the commission of an offense. And third, that Constable Senior knew this. There's a mental element, a mens rea element. It's not just that it was obtained by crime, you had to have some knowledge. So as an example, let's say I go online and I buy a shotgun and I pay full price for it from a person who seems legitimate. And unbeknownst to me, this guy has stolen the shotgun. And there was no signs of it. There's no indicators. It's not like this guy was selling it to me at pennies on the dollar or was behaving suspiciously or anything like that. I wouldn't be able to be convicted of possession of firearm obtained by commission of an offense because I didn't know. So that's why that mental element is there. It's to avoid convicting people who are morally innocent. So analysis and conclusion in relation to possessing a firearm obtained by crime. Constable Senior has conceded that, so this is stuff that he's agreed to, he's admitting, he's not fighting on these points. So one, he was in possession of a firearm when he physically transferred the shotgun from the Tahoe to the back of the rental van. There is no question that the shotgun was a firearm within the definition of Section 2 of the Criminal Code. And also that it doesn't fall within 84 sub 3. I don't think they ever mentioned that, but the shotgun's not going to qualify under there. He knew that he had committed a crime, i.e. theft, to obtain the shotgun. This court agrees that the Crown has proven beyond a reasonable doubt that Constable Senior was, and knew he was, in possession of a firearm, a shotgun, obtained by the crime of theft when he physically transferred the shotgun from the Tahoe to the back of the rental van, and that he should be found guilty of this offense. Constable Senior unlawfully took the shotgun, which was the property of the police, meaning to temporarily deprive the police of it during the lead up to this warehouse plan. Constable Senior knew he was not legally entitled to transport the shotgun to LA Fitness, remove it from the Tahoe, and place it into the back of the rental van, unsafely stored, for the purpose of robbing a drug warehouse. Kinda obvious on that one. He physically possessed the shotgun when it was in the Tahoe, up until he placed it into the trunk of the rental van. The only point of disagreement on this count is whether Constable Senior constructively or jointly possessed the firearm after he placed it into the trunk. So once he puts it into the trunk, is he still in possession of it? Because, and this one gets people a lot of the time, people say, well, how can I be in possession of something if it wasn't in my hands? Well, possession extends beyond sort of what's in your hand. I have no firearms in my hands right now, but I'm in possession of a whole bunch of them because they're in my house. They're in my gun safes. They're in places I have access to. So that makes them something that I'm in possession of, notwithstanding the fact that my hands are empty here. So it is the view of this court that Constable Senior possessed the firearm when he transferred it and after he transferred it. The firearm was put in the van in preparation to carry out this robbery, which will be discussed below. The rental van was intended to be the vehicle that UC1 and Constable Senior would use to travel to the warehouse, and it contained numerous pieces of equipment to carry out that robbery. The van was being used to store all of the necessary items. The plan was to, jointly, use this van in this joint endeavor to rob the warehouse. Constable Senior had not given up or abandoned possession of the firearm when he placed it in the van. He was storing it for later use. It would appear that UC1 held the keys to the van as he talked to Constable Senior about going back to move the van later on in the day. However, who held the keys is of no moment. Constable Senior certainly knew that the firearm was in the van, as he put it there and intended to use it later on. Constable Senior continued to have constructive or joint possession of the firearm as he continued to have knowledge and control over the firearm, even though he clearly consented to having UC1 deal with the van later on that day. So as you can see, possession is a more complicated subject than just what's in your hand at any particular moment. People also get tripped up on this idea of joint possession. You know, we were both in the vehicle and the gun was on the other guy. How can I be in possession of it? Well, if there's knowledge and control, you can still be in possession of it, notwithstanding the fact that somebody else might physically have it in their hands. So therefore, Constable Senior is guilty of count 6, possession of a firearm obtained by crime. So law in relation to weapons dangerous. In order to find Constable Senior guilty of possession of a weapon for a purpose dangerous to the public peace, this court must be satisfied of the following essential elements beyond a reasonable doubt. Essential elements are just when you take a criminal offense and you break down the language into each of the bits, the key pieces that have to be proven. That's what the essential elements of offense mean. This is kind of an important task in lawyering in the criminal sphere, either on the part of the Crown, who has to figure out these are the things I have to prove if I want to make out my case, or on the part of the defense, because you're trying to do the opposite. If you can knock out one of those essential elements, any one of them, you can get an acquittal. So it's really important to know what those essential elements are so that you know what you're fighting over. So first, that Constable Senior possessed a weapon. B, that Constable Senior knew that he possessed a weapon, and that Constable Senior had the weapon for a purpose dangerous to the public peace. Some of this sounds obvious, and some crimes break down into more obvious things and some into less obvious things. This one's fairly obvious. Now, when they say knew that he possessed a weapon, you know, let's say that you picked up something and you think it's a toy shotgun. You don't know it's a real shotgun. Well, then in that case, you might not know that you possess a weapon, notwithstanding the fact that in law, that shotgun is always a weapon because it's a firearm. So in the Queen and Proverbs, the court stated as follows: that purpose must be determined at an instant of time which preceded the use of the weapon. The use of the weapon in a manner dangerous to the public peace does not constitute the offense, although the formation of the unlawful purpose may be inferred from the circumstances in which the weapon was used. So just because a weapon is used in a crime or for some other purpose dangerous to the public peace doesn't necessarily establish this offense. Let's consider a bit of an unusual example. You've got two people working on a job site, and let's say they're working with hammers, and they get into a dispute. Some reason, you know, they have some sort of argument, and one of them picks up a hammer and clocks the other guy. Well, the reason why they had the hammers is as work tools, because this is a job site. So they would be unlikely to be able to be convicted of possession of a weapon for purposes dangerous to the public peace, because it only became a purpose dangerous to the public peace when they actually started trying to smack each other with the hammers. But if you take that same item, a hammer, and you imagine somebody who is upset, you know, the same two guys, they're not at the job site, but instead the guy visits him at his house later that day. And he brings a hammer from the job site, tucks it into his pants, goes to the other guy's house, rings the doorbell, and when the guy opens the door, bam, hits him with the hammer. At that point, the court would say, listen, this is possession of a weapon for purposes dangerous to the public peace, because during that time when you were going to his house, that was still for a purpose dangerous to the public peace. You were going there for the purpose of having this confrontation and being armed with the hammer when you did so. So that's a bit of a technical distinction, but that's what they're going on with here. So analysis and conclusion in relation to weapons dangerous. The defense conceded that the Crown has proven beyond a reasonable doubt that Constable Senior possessed a weapon, the shotgun, and that Constable Senior knew it was a weapon. He knew it was a shotgun, that's why he wanted it. However, the defense submitted that there was insufficient evidence to establish, beyond reasonable doubt, that Constable Senior possessed the shotgun for a purpose dangerous to the public peace, or for the purpose of committing an offense. It was argued that while Constable Senior was clearly in possession of the shotgun on October 9th, 2018, there was no clear agreement to use this shotgun in the commission of the purported robbery, as there had been a discussion about getting a different or even a second firearm, and discussions were ongoing about whether they would go in heavy and what material may be required to do so. The defense submitted that, until the moment the plan had materialized, there was no clear intention on Constable Senior's part for possessing the shotgun. At the moment Constable Senior possessed the firearm, it was not for a dangerous purpose. The defense submitted that Constable Senior, at the point of possession, had not advanced beyond mere preparation in relation to the robbery, and the intended use of the shotgun was still unclear. So he's basically saying he's got the shotgun to maybe commit a robbery, but he hasn't decided on committing a robbery yet, so it's not a purpose dangerous to the public peace. I don't think this is the strongest argument, but I don't think the defense has a whole lot of other arguments here. So, I'm not faulting the defense lawyer on this, rather the opposite. This is, I don't know that I would have come up with this argument. It's not ridiculous, but I don't think it's strong, if that makes sense. So it is the view of this court that Constable Senior possessed the shotgun, a weapon, when it was in the Tahoe up until he placed it into the back of the rental van, and constructively or jointly possessed it after he placed it into the trunk of the rental van. Constable Senior knew it was a shotgun, which is a firearm, and therefore a weapon. Constable Senior possessed the shotgun for the specific purpose of robbing a drug warehouse. That's kind of a purpose dangerous to the public peace, right? Constable Senior and UC1 had been discussing how to get a shotgun from the station for the purpose of robbing the warehouse since September 24th, 2018. On that day, Constable Senior mentioned going in heavy and said, unless we take from the station, that's a lot of heat. UC1 asked, what, you want to bring shotguns? Constable Senior said, maybe shotguns or ARs. I'd say more shotguns. You see that Constable Senior has this tendency to kind of agree with what his partner says. He's a very agreeable kind of guy, which is not to his credit here. Constable Senior then made some suggestions about how to get the shotguns out of the station. Constable Senior clearly had a dangerous purpose in mind, i.e. robbing the warehouse, many days before the possession occurred on October 9th, 2018. However, the purpose continued on October 9th, 2018. At the breakfast meeting that morning, Constable Senior confirmed with UC1 that the shotgun was still in the Tahoe. UC1 asked if he wanted to get the shotgun now. Constable Senior said 100%, since Henry could call today or tomorrow. Ultimately, they agreed to take the shotgun out of the truck that day, which is exactly what happened. Constable Senior's purpose for possessing this shotgun, robbing the warehouse, continued until he was arrested. Regardless of whether the plans were still in flux or not, there's absolutely no question that the only reason Constable Senior put the shotgun into the back of the rental van was to obtain it for use in the robbery of the warehouse. There's no question that this is a purpose dangerous to the public peace. Constable Senior is accordingly guilty of count 7, possession of the shotgun for a dangerous purpose. That probably isn't surprising anyone watching this right now. Now we're going to get to some interesting and technical law, which I think is fun, but it's also law involving shotguns and drug robberies, so bear with me here. Law in relation to attempted robbery. So section 343 provides that, and this is the robbery section, everyone commits robbery who, A, steals and for the purpose of extorting whatever is stolen, or to prevent or overcome resistance to the stealing, uses violence or threats of violence to a person or property, or B, steals from any person and, at the time he steals or immediately before or immediately thereafter, wounds, beats, strikes, or uses any personal violence to that person, or C, assaults any person with intent to steal from him, or D, steals from any person while armed with an offensive weapon or imitation thereof. Now this kind of confounds a lot of people because they say, I didn't rob somebody, I just stole something from a store, and then I was running away, and when the loss prevention officer started catching up with me, I gave him a couple of good shots to the head to get him to stop following me, and so how's that a robbery? Well, that would be under section 343 sub B, immediately thereafter, wounds, beats, strikes, or uses any personal violence to that person. So lots of people sort of have an overly narrow idea of what robbery consists of. it's a fairly broad term. It's basically the combination of theft and violence in some fashion, including just simply being armed. As for an attempt to commit robbery, Section 24 of the Criminal Code provides that everyone who, having an intent to commit an offense, does or omits to do anything for the purpose of carrying out the intention is guilty of an attempt to commit the offense, whether or not it was possible under the circumstances to commit the offense. The question whether an act or omission by a person who has an intent to commit an offense is or is not mere preparation to commit the offense and too remote to constitute an attempt to commit the offense is a question of law. So there's a few things here that you might say, what does that mean? So does something or omits to do something? How can you omit to do something for the purpose of committing an offense? Well, let's say you work at a jewelry store and you have the job of locking up at night. And so instead of locking up at night, you decide to just forget to lock the door because you know you're going to be coming back later and you're going to steal stuff, or maybe your buddies are, or you forget to set the alarm. Those are examples of omitting to do something for the purpose of later committing an offense. You know, in this case, a breaking and entering and likely theft. And so when they say whether or not it was possible under the circumstances to commit the offense, you know, let's say your goal is to break into the store after hours because you want to steal that jewelry. But unbeknownst to you, you've left the door unlocked and somebody else gets there first. They steal all of the jewelry. And so when you get there, there's nothing left. Well, notwithstanding the fact that it wasn't possible for you to steal any of the jewelry because it's gone, you can still be found guilty potentially of an attempt to steal it. Now, the too remote to constitute an attempt is complicated, and that's what they're about to get to, so I'm not going to go through that right yet. We'll get to that as they consider some examples here. So the Crown must prove beyond a reasonable doubt that first, Constable Senior intended to do that which would amount in law to the robbery specified in the indictment, and that's a mens rea issue, and B, that he took steps in carrying out that intent which amounted to more than mere preparation. Mere preparation doesn't get you into an attempt. You have to take some step beyond preparation. It doesn't have to be a substantial step, but it has to be something beyond preparation. And the court is going to try to explain what this difference is, because I'm sure lots of people are shaking their head going, what does this mean? And the way they're going to have to do that is by looking at some prior case law. So no single bright line or criterion is determinative of the distinction between mere preparation and attempt in this context. The location of the act or acts in question on this continuum are a matter to be determined by the trier of fact, that's the judge, or the jury potentially if this was a jury matter, on a case-by-case basis. As Watt explained in the case of the Queen and Root, in every case of an attempt to commit an offense, the mens rea of the substantive offense, that's the thing you're trying to do, that thing you're trying to attempt to do, will be present and complete. In every attempt, what is incomplete is the actus reus of the substantive offense, the actual act itself. But incompleteness of the actus reus of the substantive offense will not bar a conviction of attempt, provided the actus reus is present in an incomplete but more than preparatory way. The actus reus may be, but does not have to be, a crime, tort, or even a moral wrong. So if we consider the example of forgetting to lock up the store, that probably isn't a crime, or it might be negligence, but maybe not. I'm not a civil lawyer. I don't do a whole lot of tort stuff, or even a moral wrong. So it can be something that you are actually entitled to do, but so long as you're doing it for the purpose of committing a crime. Let's say you plan to rob your buddy. Calling up your buddy and saying, hey, can you meet me at this place, isn't a crime or a tort or even a moral wrong. Just the simple act of asking them to meet you at some spot. But it can still make out that you've started the act of robbing that person. So the authorities have yet to develop a satisfactory general criterion to assist trial judges in making the crucial distinction between mere preparation on one hand and attempt on the other. We leave the determination of where on the continuum the conduct lies to the common sense judgment of trial judges, which is something people often criticize. There's sometimes not clear, bright line rules. And the way you get to these things is by looking at cases, looking at examples. So the distinction between preparation and attempt is a qualitative one involving the relationship between the nature and quality of the act said to constitute the attempt and the nature of the substantive offense attempted in its complete form. That's kind of ugly. There's a lot of sort of long words in there. Basically, you have to look at the nature of the acts and sort of how they fit into the completed act, how they fit into the actual offense that you were trying to do. To constitute the actus reus of an attempt, the act of an accused need not be the last act before the completion of a substantive offense. To constitute the actus reus of an attempt, an act must be sufficiently proximate, so close enough in terms of time and place and so forth, to the intended crime to amount to more than mere preparation to commit it. This requirement of proximity, expressed in the divide between preparation and attempt, has to do with the sequence of events leading to the crime that an accused has in mind to commit. To be guilty of an attempt, an accused must have progressed a sufficient distance beyond mere preparation down the intended path. An act is proximate if it is the first of a series of similar or related acts intended to result cumulatively in a substantive crime. All right, as I said, we're going to look at a bunch of examples here. So this court has considered a number of cases dealing with the offense of attempted robbery in considering whether these circumstances amount to mere preparation or a step in the commission of an offense. While it is not difficult, and this is from the case of the Queen and Klein, while it is not difficult to define the mens rea of an attempt, a precise and satisfactory definition of the actus reus is perhaps impossible. So in the case of the Queen and Sorrel, the Crown appealed against the acquittals of the respondents on a charge of attempted robbery. The allegations were that the accused attempted to rob an employee of Aunt Lucy's Fried Chicken. On the night in question, the store closed a bit earlier than scheduled. After locking the door, an employee noticed two men wearing balaclavas at the side of the store. I bet at that point you're feeling pretty good about locking up early. They then came to one of the customer entrances. The balaclavas were pulled down completely over their heads, and one was wearing sunglasses. One of the men knocked on the door, and the manager said, "Sorry, we're closed." An employee of the store noticed one of the men had a silver-colored gun in his hand. The two men then walked away. Police were called, and the men were arrested. One of the accused, Sorrel, had a loaded .357 Magnum revolver concealed in his waistband. In dismissing the Crown's appeal, the court stated as follows. So these were people who were acquitted, notwithstanding the fact that they went up to the store with balaclavas on their face and a gun in their pants. At least acquitted of the attempted robbery. I suspect that there were other charges that they might have been convicted on, but I haven't looked up the case. So if the trial judge had found that the respondents intended to rob the store, the acts done by them clearly had advanced beyond mere preparation and were sufficiently proximate to constitute an attempt. So if that was their goal, that would have made it out as an attempt. Because of the doubt that he'd entertained that the respondents had the necessary intent to commit robbery, however, his error in law in holding that the respondents' acts did not go beyond mere preparation could not have affected the verdict of acquittal unless, of course, his self-misdirection with respect to what constituted mere preparation led him into error in entertaining a reasonable doubt as to whether the requisite intent had been proved. So this was a situation where it would have clearly been beyond mere preparation, but the trial judge said, I don't know that they were actually going to rob this place. Maybe they just finished robbing someone else and they just wanted some chicken. It's an example, but I don't know that this is it's a bit of a strange example. Let's continue on to another one. In the case of the Queen and Rawson, the four accused were charged with conspiracy, attempted robbery, and possession offenses. The police observed the accused watching a tobacco company. When a truck left with a delivery of products at the same time as it did every week, the four accused followed the truck. The following week, the accused were observed watching the tobacco company from the same area. Upon observing that the accused were in possession of what appeared to be weapons, the police executed a takedown. The police found weapons, handcuffs, gloves, masks, a padlock, and duct tape in the accused vehicles. The court held that each of the accused intended to commit a robbery and that the attempt to do so was underway when the takedown took place. Weapons were present. Vehicles for transporting goods were on scene in the possession of the accused. The accused were in possession of paraphernalia useful in a hijacking and robbery, including gloves, duct tape, masks, handcuffs, a linoleum razor, and a padlock. The court held this was not just another dry run. This was an operation that was underway and would have been mobile within a short time of the takedown. If the accused did not move against the Thompson truck, they would have moved against the truck that was either loading or would load soon thereafter with a destination of Vancouver Island. These passages confirm my opinion that the acts of the accused in the case at bar were an attempted robbery and not merely planning. The quality of the acts of the accused, their nature, and proximity to the proposed robbery all weigh in factor of such a finding. So simply the planning, when they're sitting there casing the place out, thinking about it, that's not the attempted robbery. But once they've got all of that gear and they're ready to go, it's go time, that makes it into an attempted robbery. Now you might say, why aren't we criminalizing the act of casing the place out? Well, it's not illegal to watch the place and you might change your mind, but there may also be other crimes involved in that planning, depending on circumstances. So in the case of the Queen and Dennis, Mr. Dennis was observed by the police sitting for a long time in a car watching a restaurant with binoculars. At one point, Mr. Dennis drove over to an unmarked police car and peered inside. When it was close to the restaurant's closing time, they arrested him. They found a stolen handgun, loaded and cocked with a round in the chamber, in his car. A bandana was also located in his car. Mr. Dennis testified that he was merely casing the restaurant but had not yet decided to carry out a robbery. Mr. Dennis sounds like he's been reading some legal texts here. So the court stated, first counsel contended that the preparation stage had not ended and no step to put the design into action had begun, so the offense of an attempt was incomplete. The trial judge saw and heard the witnesses, especially Mr. Dennis, and some evaluation of his personality and character must be relevant to that question. For example, is he a meticulous or an impulsive person? Is he decisive or indecisive? Seeing the witnesses gives an advantage. And in our view, and this is where I'm going to have some issue with this one, cocking the gun was something the trial judge could well consider as going beyond preparation. It certainly gives the lie to merely casing with no decision to rob. Driving over to peer into the unmarked police car might also go beyond preparation. We repeat that the closing time of the restaurant was only 11 minutes away. It would close without Mr. Dennis's having to take a single other step. I don't really necessarily agree with them when they say cocking the gun was something that goes beyond preparation, because who knows when he cocked this thing? You know, this could be a guy who always carries around a gun in a cocked state. I mean, it's not great for safety, but the guys committing these kinds of things don't typically concern themselves all that much about safety. So there's no indication here that I can see, and again, I haven't looked at the full case here, but simply saying cocking the gun indicates preparation. It's not like the gun uncocks itself. It could be cocked for weeks. So I don't know. I haven't dug into the full case to see what's going on there, but I just kind of go, I don't know. It's one of those places where I wonder if the underlying case might have had some problem with sort of firearm knowledge, and people, including people in the justice system, often assume that they have more knowledge of firearms than they actually do. They say, hey, I've watched a lot of movies. You know, you don't cock the gun until it's time to go. Well, you can't necessarily draw conclusions from your experiences through popular culture. All right, we're going to skip over a bunch more of these because there's a whole lot of them, and I want to keep this not too long. And there's a bunch more counts we got to get through. So analysis and conclusion. The evidence clearly establishes that Constable Senior believed that there would be cocaine and/or cash at 84 Colville Road, and that he would potentially profit greatly from robbing it given the following circumstances. And you remember he thought that there would be potentially 5 to 10 kilograms at 30 kilograms a pop, so $150,000 to $300,000. That's a lot of dollars, especially when you consider that he's probably not planning on declaring this on his taxes. I don't think there's really a line item on the tax thing for, I got this committing a drug robbery. Although if you do commit a drug robbery, the the tax people do want their cut of it. They do consider all of that They do consider income from crime to be taxable income. So it is the view of this court that Constable Senior intended to commit the robbery. Constable Senior's detail-oriented efforts and utterances demonstrate his intention to carry out the robbery, and he took numerous steps in preparation toward that goal. He spent significant time and effort in formulating and reformulating the operational plan for the robbery. The plan was thorough and detailed. It addressed, first, needing a third party to keep 6. Mr. Papoutsos was even approached about the job and offered a half brick of cocaine for payment. However, it was later decided that the 2 officers could handle it on their own. How to avoid detection. What equipment was needed. How to deal with the warehouse occupants, such as the use of zip ties and duct tape. Whether to be armed and what firearms to use. There were discussions about shotguns versus assault rifles and how to obtain such without arousing suspicion. What to wear. What code words to use. How and to whom to offload any drugs found and at what price. Constable Senior had talked to Henry about offloading cocaine and a suitable price. The discussions with Michael Vigliotti were not as clear. Various risks and how to deal with them, such as the potential for the occupants of the warehouse to be the subject of intercepted communication, using Mr. Vigliotti if he was under police surveillance, the potential for GPS tracking, and the possibility of leaving DNA or fingerprints. There were numerous discussions about what equipment was required, and many items had already been collected, initially in UC1's vehicle and then later transferred to the van. Compiling the equipment required shopping trips to Walmart and Home Depot, which was done. There had been 2 trips to the warehouse to do some surveillance. Each time UC1 suggested withdrawing from the plan, Constable Senior expressed the desire to move forward. On September 24, 2018, Constable Senior even raised the idea of simply providing the information to Detective Sergeant Bedford, but then immediately abandoned the notion and stated, "But that's a big score. $100,000 plus 5 pieces." The plan to rob this warehouse was discussed on numerous days starting on September 12, 2018, and was a topic of conversation each time Constable Senior and UC1 were together thereafter. The numerous items found in the rental van on October 9, 2018 demonstrate Constable Senior's serious intention to carry this plan through to completion. Constable Senior even took advantage of an opportunity to steal a YRP shotgun and place it with the other equipment that he had amassed for the robbery, because he expected that Henry could call at any moment to advise that the drugs were at the warehouse, especially given that Henry had said Tuesday or Wednesday. October 9th, 2018 was a Tuesday. This court agrees that the evidence firmly establishes that Constable Senior intended to commit a robbery. The Crown has proven the mens rea element beyond a reasonable doubt. The remaining question that this court needs to address is whether this plan had gone far enough to amount to an attempt. So keep in mind all of the stuff he's done. So, he's got the shotgun, he's got zip ties, he's got all of this stuff, he's planned things out. So the defense conceded that the intended crime itself was a robbery, and that the 2 officers had floated numerous ideas and were developing a plan. However, submitted that the actual plan to commit the robbery was incomplete on October 9th, 2018, when Constable Senior was arrested. The Crown submitted that Constable Senior was ready, his planning and preparations were complete, and he was ready to go at a moment's notice, simply waiting for the signal. The Crown argued that Constable Senior advanced past mere preparation at the latest when he stole the shotgun and placed it in the van. Now, I've got an underlining here on ready to go at a moment's notice. Ready to go sounds like completed preparation, but remember, you got to go a step beyond preparation. Ready to go, if that was the Crown's line, that may have been a strategic error or a misphrasing if they wanted to get the conviction here. If it's the judge's phrasing, then the judge is kind of giving us some spoilers here. So the actions in this case would clearly amount to a conspiracy in that there was, seemingly, an agreement between 2 persons to commit the robbery sometime in the future, but for the fact that UC1 was working undercover and had no such intention. It's not a conspiracy because it's an agreement between one guy who plans to do it and another guy who's an undercover cop. So that, I'm not going to get too much into conspiracy law here, but that is a very relevant detail. So, however, an attempt requires more, a step in carrying out that intent which amounted to more than mere preparation. In other words, all preparation must be complete. there must be a step in the commission of an offense, so a step after the preparation. While the preparation was detailed, there were still significant aspects of the operational plan that had yet to be determined. Though Henry was expected to call at any moment based on the state of the plan at this point, it cannot be said that the plan was complete and that Constable Senior had taken a step toward the commission of the offense. On October 9th, 2018, the following central aspects of the plan were still undetermined. 1. A date and time for the robbery had not been established. 2. No decision had been made as to whether further firearms were needed and what those firearms would be. 3. No decision had been made as to where to set up and wait for Henry's call. 4. No decision had been made about where to physically take and offload the product. And 5. There were still ongoing discussions about how and with what to blind the cameras. So on October 9th, there were still too many unknowns for Constable Senior's actions to amount to an attempt. From the intercepted communications and UC1's own testimony, it is evident that the transferring of the shotgun from the police Tahoe to the rental van was still just preparation. The shotgun was available in the police Tahoe for several days before October 9th. UC1 suggested to Constable Senior that they get it now, not knowing when they would need it. The taking of the shotgun was not the completion of the preparation in the sequence of events leading to the robbery, as evidenced by the facts in this case. So, given that his actions had not progressed beyond mere preparation, Constable Senior is not guilty of an attempted robbery. That one might surprise people, considering all the stuff that he was getting ready to do, but he hadn't quite gone far enough to get to an attempt. So next we're going to look at law in relation to trafficking cocaine by offer. And this is kind of an interesting thing because you can be convicted of drug trafficking notwithstanding the fact that you didn't actually have any drugs. And in fact, that you never actually planned to give anybody any drugs. So the Crown alleges that Constable Senior offered to traffic the cocaine he expected to find in the warehouse to George Paputzos, Michael Vigliotti, and Henry Wong. Section 2 sub 1 of the Controlled Drugs and Substances Act defines traffic to include the following. So traffic means in respect of a substance included in any of Schedules 1 to 5, so the sections that say what drugs are illegal. A, to sell, administer, give, transfer, transport, send, or deliver the substance. B, to sell an authorization to obtain the substance. Or C, to offer to do anything mentioned in paragraphs A or B, otherwise than under the authority of the regulations. Trafficking by offer requires, so first, an offer to traffic in a scheduled substance, and second, an intent to make an offer that will be taken as a genuine offer by the recipient. Note, that doesn't mean you have to actually make a genuine offer. You can have an offer that is purely fake. So let's say you're walking down the street and you've got a baggie of white powder, and that white powder is ground up chalk or some random, bit of crap that you found on the ground. It is nothing that will get you high. But you go up to somebody and you say, hey, do you want to buy some cocaine? And you show them this bag of inert white powder. And that offer, if you're intending for the other person to think that you're actually planning on selling them cocaine, can be drug trafficking, even though you don't have any drugs. So lots of people get surprised by that one, but that is one of the ways you can be convicted of drug trafficking. So there's no requirement that the offer be accepted or that consideration pass between the parties. Consideration is, exchange of things of value. Things of value in this case can be promises, binding promises in some fashion, but something of value, you don't actually have to exchange anything. So there's also no requirement that the accused intended to carry out the offer or even had the means to provide the drug in question. Accordingly, it is of no moment that Constable Senior did not have access to the cocaine that he believed he would find in the warehouse. Neither is it relevant that the drugs would never have materialized. The offer itself makes out the offense. An agreement is not required. The factual impossibility of fulfilling any such agreement is, therefore, irrelevant. And they also note there is no need to prove both the intent to make the offer to sell and the intent to carry out the offer. And Sherman was later followed on this point in Mancuso, where the accused argued unsuccessfully that he did not intend to actually sell narcotics to a police informer, but really wished to steal his money. So the mens rea on this isn't that you actually intend to transfer any drugs or anything like that, just that you intend to make the offer. That's it. All right, so analysis and conclusion in relation to trafficking by offer. Well, intend to make the offer and intend for somebody to believe that it's a serious offer. So it is the view of this court that the offers made by Constable Senior to George Papoutsos and Henry were intended to be taken as a genuine offer by the recipient. This court has already found that Constable Senior intended to rob the warehouse on Colville Road and that he expected to find cocaine inside. Part of the plan was to offload any cocaine found for profit. The intercepted communications demonstrate the intentions of Constable Senior beyond any reasonable doubt. There is no question that Constable Senior was serious about his offer and intended to convey that to Mr. Papoutsos. This is the only reasonable inference. With respect to Henry, on September 23, 2018, Constable Senior talked to Henry about the hypothetical of a cowboy crew going in to do the raid and whether Henry would be interested in buying the drugs. Henry said he would have to think about it, but would not turn down business. On October 6, 2018, Constable Senior texted Henry and said that they agreed at that number of 30 a box, and agreed that if there were 5 to 10 kilograms in the warehouse, Henry could buy all of it. Again, there's no question that Constable Senior was serious about his offer and intended to convey that to Henry. That is the only reasonable inference. It is of no legal moment that Constable Senior did not have access to the cocaine that he believed he would find in the warehouse, nor is the factual impossibility of fulfilling any cocaine sale relevant. Constable Senior was clearly unsure about what he would find in the warehouse and what assistance he would need if he had to offload the product. However, it is that offer that makes out the offense. The fact that Constable Senior did not know whether there would be any cocaine in the warehouse is not relevant. With respect to Michael Vigliotti, while the conversation is highly suspicious, it is not clear to this court that an offer was made, as opposed to simply a discussion about the product and possible pricing. It is not clear in this conversation whether Constable Senior was making an offer to Mr. Vigliotti, or simply seeking his input as to potential pricing for the quantity and quality of the drugs being discussed. This court is unable to conclude beyond a reasonable doubt that an offer was made. For all of the foregoing reasons, Constable Senior is guilty of offering to traffic cocaine to George Papoutsos and Henry, but not in relation to Michael Vigliotti. So there's a distinction there. There's a difference between these individuals, and that's because there were serious offers to two of them, but the third one, the judge has some reasonable doubt as to whether or not there was a serious offer or whether they were just bantering about possible prices. So all of which, sort of explains and shows a little bit of the law here. I'm skipping over some charges related to breach of trust, but I do want to look at the charges relating to trafficking steroids to Constable Timur Berlatov and to Undercover Officer Number 1. That's his fake partner. Both of these people were said to have asked Constable Senior for help in terms of getting steroids, and so the law here I think is quite interesting. Let's dive in. So as stated above, Section 2.1 of the Controlled Drugs and Substances Act defines traffic to include, in respect of any substance listed in Schedule 4, to sell, administer, give, transfer, transport, send, or deliver the substance, or to offer to do any of these activities. This definition covers all stages of the continuum. There is no requirement that the trafficker obtain a material benefit from their role in the transaction. So when we think of drug dealers, we're usually thinking of people doing so for profit. But that's not the extent of trafficking. The trafficking charge can apply to what we call social trafficking, sharing drugs. So if one guy goes and buys some cocaine and shares it with his buddy, he's a drug trafficker in law. A lot of people don't really expect that, but that's the way the law works. Now, this raised some interesting questions, and we'll kind of look at how the law has looked at the distinction between trafficking and possession. So in The Queen and Grey Eyes, the accused had assisted an undercover police officer both to find a source of cocaine and then to buy a quantity of it. The officer paid him for his help. The accused was initially acquitted of trafficking, which was overturned on appeal. So he's acquitted at the trial level, and then the Court of Appeal either directed a new trial or possibly convicted him. I'm not sure, but later on it ends up at the Supreme Court, which is the case that we're going to care about here. So the matter then came before the Supreme Court of Canada, the issue to determine being whether someone either acting as an agent for a purchaser of narcotics or assisting a purchaser to buy narcotics could be found to be a party to the offense of trafficking under Section 21.1 by aiding or abetting in the sale. So a party to the offense means you didn't necessarily do the thing, but you're brought in and you have legal culpability for it because you're kind of along for the ride by, in this case, aiding or abetting, assisting. So essentially they were saying that by buying drugs, you're helping drug trafficking happen. Let's see what the Supreme Court had to say about that one. So certainly there can be no doubt that someone who purchases a narcotic must assist the vendor in completing the sale. Without a purchaser, there could be no sale of the narcotic, right? Because you can't sell a drug without somebody buying the drug. However, Parliament has chosen to address the culpability of purchasers in a different fashion. As soon as someone obtains possession of a narcotic, he or she may be charged with possession or possession for the purpose of trafficking. So there's different charges that are there and applicable. Yet it is clear that the person does not come within the definition of trafficking, nor can he or she be found guilty of aiding or abetting the offense of trafficking on the basis of the purchase alone. Parliament has created other offenses under which a purchaser may be charged as a result of the purchase. So the Supreme Court said, listen, charge them with possession for the purpose of trafficking if they're planning on reselling it, but there's something different between somebody buying drugs and somebody dealing drugs, and that makes sense, right? It seems it would be a little weird to say that you're guilty of trafficking drugs just because you bought some. In my view, this excerpt clearly demonstrates the important distinction between vendor and purchaser. I agree that despite his or her crucial assistance in helping to complete the sale of narcotics, the purchaser cannot, by this action alone, be found guilty of the offense of aiding or abetting the offense of trafficking. Frankly, I see no reason why this reasoning should not be extended to third parties as well. In situations where the facts reveal no more than incidental assistance to the sale through rendering aid to the purchaser, it stands to reason that these persons should be treated as purchasers and not as traffickers. The proper charge in these circumstances would be aiding or abetting the possession of a narcotic and not trafficking. So what the judge here is saying is you have to look at who they're helping when you're talking about somebody who's acting as an intermediary. If they're helping the person who's buying the drugs, well, then they should really be at the same level of responsibility as the purchaser. Whereas if they're helping the seller, then they get that higher level of responsibility. So, and that makes sense to me. The court also notes the offense of aiding or abetting possession of a narcotic is a permissible legal result and has occurred on many occasions. See, for example, the Queen and Miller. What the judge is saying there is, I'm not forging new ground. I'm not making stuff up here. This is not new ideas. This is something the courts have done before. Now, this is, I think, a little bit kind of novel, but the court is grounding this to say, listen, there's some prior case law, and this is not something that is strange or foreign. Fair enough. So perhaps more importantly, I believe this approach benefits from a certain symmetry. It is clear that someone whose acts are designed to aid a purchaser, yet incidentally benefits the seller, has assisted much more in the purchase of the narcotic than in the sale. As such, it is only fitting that this person share the culpability and stigma of the purchaser rather than that of the vendor. So it's kind of a which team are you on sort of argument here. In the case at bar, however, I have no difficulty in concluding that the appellant did far more than act as a purchaser. My colleague has described the nature of the appellant's participation in the sale in detail, and these facts demonstrate a concerted effort on his part to effect the transfer of narcotics. The appellant located the seller, brought the buyer to the site, and introduced the parties. It is clear that without this assistance, the purchase would never have taken place. Moreover, he acted as a spokesperson, negotiated the price of the drugs, and passed the money over to the seller. He also accepted money for having facilitated the deal. As my colleague points out, without the appellant's assistance, the buyer would never have been able to enter the apartment building and contact the seller. These are not the acts of a mere purchaser, and as a result, it is clear that the appellant aided the traffic of narcotics. So that's again quoting the decision there. So this is not applicable to our current scenario. This is a quote from Gray Eyes. All right, so moving on a little bit here. Analysis and conclusions in relation to trafficking to Constable Timur Berlatov. The defense submitted that while there is no requirement that the trafficker obtain a material benefit from their role in the transaction, Constable Senior's interest in this transaction was still important when considering the argument that he was acting as an agent for the purchaser. The defense argued that at no point in these transactions was Constable Senior attempting to serve his own interests. His interest was in facilitating the purchase of the steroids, not the sale. So he's helping his buddy, Constable Timur Berlatov, and he's not trying to make a profit off this. He's not trying to, get ahead. So that is part of the defense's argument here, and saying that that's relevant to considering who he's helping. If he's helping the drug trafficker, why wouldn't he get a little something on the side for himself? But if he's just helping his buddy, then maybe not so much. Makes sense. I wouldn't say it's determinative, but I'd say it makes sense as an argument. So they say, while the text messages are highly suspicious, this court is unable to conclude, beyond a reasonable doubt, what role Constable Senior played in the final crucial steps of the transaction. It was expected that he would take the money collected from Constable Timur Berlatov, go purchase the steroids from George Papoutsos, and then deliver them to Constable Timur Berlatov. This may, in fact, be exactly what happened. However, this court is unable to conclude this beyond a reasonable doubt. There is no evidence that Constable Senior provided the money to George Papoutsos. There is no evidence that he collected the controlled substance. There is no evidence that he brought a controlled substance to Constable Timur Berlatov. It is also not clear what product, if any, was provided to Constable Timur Berlatov. It is not clear to this court on the evidence that a controlled substance was actually handed over by Constable Senior to Constable Timur Berlatov. It would appear that Constable Timur Berlatov did receive something and referred to it in his messages on September 8, 2018. The text messages and meetings do tempt this court to draw conclusions. However, drawing such conclusions would be simply filling inferential gaps with speculation. This court is simply unable to conclude that a transaction involving controlled substances was completed. Therefore, Constable Senior is not guilty of trafficking as it relates to Constable Timur Berlatov. So basically they say, listen, there was some negotiation and so forth, but ultimately we don't know what actually happened. We don't know if he got the money. We don't know if he got the drugs. We don't know if he passed them over. Now, I don't know how much. This seems to me like it's got a potential problem here because trafficking includes the offer to traffic, and I don't see that discussed here. So there may be some grounds for potentially a Crown appeal if they feel inclined to. I'm not certain. This is something that I'm kind of waffling on, but it seems to me that simply the offer might be enough here. So it's a tough one, but really ultimately the judge is saying, listen, we just don't have enough evidence. But I think this is a potential problem with this case. I don't know if the Crown is ultimately going to want to appeal on this point. That'll probably depend on what happens later down the road. So analysis and conclusions in relation to trafficking to undercover officer number 1. So you see, he skates with respect to Constable Timur Berlatov, but that's probably because Timur Berlatov, I'm guessing, wasn't really super feeling cooperative, given the whole, this kind of implicates him. So I don't think he would have been the Crown's star witness on this. So that's where they end up with this big evidentiary gap, is they're probably missing a key witness here. So analysis and conclusions in relation to trafficking to Undercover 1. Are they going to have that same problem when Undercover 1 is really their guy? I don't think so. Let's have a look. So they might have different problems, but not that one. So the defense submitted that Constable Senior was acting as an agent for the purchaser, Undercover 1. Although Undercover 1's personal desire to use steroids was not genuine, he explicitly asked Constable Senior to assist him in getting $400 worth of steroids until Henry returned. Constable Senior used the purchaser's grocery lists, he used his money, and provided him with the product he explicitly requested. The defense argued that Constable Senior provided no more than incidental assistance to him in purchasing steroids, and that it cannot be said that without Constable Senior's assistance or intervention, that the transactions would not have occurred. Now, this is kind of a weird argument when we're talking about an undercover officer, because if we assume that the undercover officer is not going to use these steroids because, this is all part of an undercover operation, clearly the transaction isn't going to occur because the whole purpose isn't that undercover officer number 1 wants to get ripped. It's that he wants to betray Constable Senior and get him ensnared in this mess. So Undercover 1 is not going to go buy these drugs on his own. But, I mean, in a hypothetical where Undercover 1 is actually a cop trying to buy this stuff, then it might still have occurred. So it's kind of a weird application of the argument, but I don't think it doesn't make sense here. So the court is of the view that Constable Senior acted as more than simply agent for the purchaser. The following facts are of note, and we've covered a lot of those facts previously, but Constable Senior and UC1 had discussions about supplements and workouts. UC1 was attempting to segue into a discussion about steroids, but it did not occur. And that was because Constable Senior kept kind of brushing that off and saying, hey, you got to not do that. So on July 27th, 2018, UC1 and Constable Senior talked about workouts. UC1 entertained the idea of using steroids. Constable Senior objected to the idea and told Undercover 1 that he needed to work out harder and improve his diet. They had a general discussion about steroids, in which Constable Senior told UC1 that steroids from Germany and India were the best, and also that he had a friend who had 3 or 4 months prior brought steroids into the country from Mexico. They talked about the fact that it was an offense to cross the border with steroids. Constable Senior did not offer any steroids to UC1, so he's actually trying to discourage the undercover officer from using steroids. And, slowly over time, Constable Senior starts mentioning more and more that he, knows people who can get some of these steroids. He's telling Undercover 1 that they're bad for the body and that he should improve his diet first, including a proper nutrition plan and protein shakes. He's not offering to obtain steroids, but saying better diet and legal supplements. But slowly over time, it ends up going to the point where Constable Senior said that he, would get a list or would basically buy the stuff that Undercover 1 provides as a list. So Undercover 1 eventually provides him with a grocery list of what he wants for steroids. And yeah, things get worse from there. And he eventually goes and picks those up from George Paputzos, is the thought. So he was texting with Mr. Paputzos about having the money and about his friend wanting to start a cycle. And yeah. So continuing on here, as I said, we went over the facts before, so I'm just kind of skimming over them a little bit here. As for Constable Senior's role, he alone chose the seller. He discussed with the seller the products that could be purchased for this amount of money. Constable Senior set up this transaction with a person and at a location unknown to the purchaser. Constable Senior made it possible for a sale to occur that could not otherwise have taken place. In addition to the transaction that occurred with George Paputzos, Constable Senior was also negotiating with Henry for the purchase and sale of bulk steroids. For all of the foregoing reasons, this court is satisfied beyond a reasonable doubt that the offense of trafficking has been proven. Constable Senior is guilty of trafficking as it relates to Undercover Officer number 1. This suggests that had they had the sort of fill-in evidence with Constable Timur Burlatov, they might have been able to get him on that as well. So as mentioned, skipping over some of the breach of trust aspects, and we see the ultimate sort of list of convictions here. So count 1, theft, guilty, but only as it relates to the $300 payment to the Sherry Wafer source. That was him taking money that was supposed to go to undercover or to informants. Count 2, uttering a forged document, guilty. Count 3, uttering forged documents, guilty, but only as it relates to the payment as attributed to David Broadhead. Count 4, unauthorized use of computer, guilty, but only as it relates to Henry. Count 5, breach of trust, guilty, but only as it relates to Henry. And you might be saying, well, why does it matter sort of who it relates to if he's guilty on this count? Well, when it comes to sentencing and also to some other arguments to come up later, the entrapment arguments, it really matters what the facts are that the court is finding him guilty of. So that's relevant here. Count 6, possession of a firearm obtained by crime, guilty both at the time of placing it in the van and afterwards. Count 7, possession of weapons for purposes dangerous to the public peace, guilty. Count 8, attempted robbery, not guilty. Count 9, trafficking cocaine by offer, guilty, as it relates to George Papoutsos and Henry only. Count 10, breach of trust, not guilty. Count 11, trafficking with Timur Berlatov, not guilty. Count 12, trafficking to UC1, guilty. Count 13, unauthorized use of computer, guilty, but only as it relates to Aziz slash Hatziz, Fraser slash Mansour, and Simona Mara. Again, I skipped over that. Breach of trust, guilty, but only as it relates to Aziz Hatziz and Fraser Mansour. So this is a big decision, and there's going to be a lot of questions about this. The big one here is what happens next, because, this is an officer who's now been found guilty of a number of offenses. So the next argument that is going to happen, I'm not sure on the timing. It may have already happened. I'll have to look into that. But there's going to be an argument made that all of this was the result of entrapment. So essentially that Constable Senior was just going about his business, and they presented him with this opportunity with, and they pressured him into it, that they incited him into it, that this is a situation where it wouldn't have occurred but for their involvement. It's not it goes beyond simply providing an opportunity to commit an offense, but into an incitement to commit an offense, into pressuring somebody or the like. And so as an example of sort of a distinction here, simply the police leaving a bait car out there, just in a high theft area, they leave a valuable car in a place where someone might try to steal it. That's not entrapment. It's up to you whether you decide you want to steal that car. But let's say instead, the police officer comes up and, he knows you're hard up for money, and he says, listen, this car, is really valuable to me personally. I'll pay you above market price for this car. I just need you to go and take this car. Let me, I've got a set of instruments to break into this car. I'll teach you how to do it and all of this sort of thing. Then you're looking more at an entrapment scenario, because in that case, we're talking about the police kind of pressuring somebody into it and causing the commission of the offense. So that's ultimately going to be the argument here. Now, people are probably going to say, what do you predict on this? And I'm kind of cautious about this, because you know what I haven't heard? I didn't hear any of the original evidence. And I'm only looking at the sort of the summary of the evidence, whereas the actual person who's going to decide, the judge here, has seen all of the actual evidence as it was called, seen all of these details. And so they're going to be in a much better position to make some of these assessments, because some of these assessments may come down to things like tone of voice, may come down to things like, just when you look at a transcript, you can't really get details. If you say something like, oh yeah, I really hate that guy, it's different than I really hate that guy. Inflection can matter, and we don't have any of that here, whereas the people actually making the decision do. So I don't want to be, I don't want to come down with a strong prediction on this one, but I certainly see the argument. I mean, there's several places where Constable Senior is saying, whoa, pump the brakes here. And there's several situations where the situation ends up being artificial in a way that it couldn't have happened normally. Normally Constable Senior would never have been alone with Henry. He'd have been, only seeing Henry with another person there. And they know that the reason why is because that's to prevent temptation. They know that that an undercover officer, if they're not careful and if they're not following these protocols, could be subject to being subverted. So when they're putting him explicitly and specifically into a scenario that they know is dangerous, and, this is his first rodeo in terms of navigating a difficult undercover operation like this, in terms of handling an informant in this fashion. It's clear that he's never done this before. He's relying on undercover officer number one to really guide him. And, if we imagine undercover officer number one as a corrupt police officer, the corrupt police officer isn't going to be doing the things that undercover one does. A corrupt police officer who's in it for themselves isn't going to be encouraging Constable Senior to lead. They might, in fact, have asked Constable Senior to sit out. This is a very artificial scenario. Everybody in Constable Senior's life here appears to have been on sort of a common purpose. And that common purpose is to get him to commit these offenses. It's very strange when we start thinking about, this in terms of, would this offense have actually happened, or could it have happened absent this? Is this just merely presenting with an opportunity? I think I'm kind of inclined to think it goes beyond that, because there's several places where they're overcoming his resistance. And I mean, I'm betting that they had substantial meetings about how do we get Constable Senior to, to take the bait? How do we do these things? Ultimately, I can't predict one way or the other what this is going to be, but I mean, it starts out with this investigation into Constable Senior for fairly minor things. They think he's maybe misusing the computer systems. And they take it to some really interesting places really quickly, where they're like, hey, we think this guy's misusing computer systems. Let's run this whole big thing with this whole fake drug dealer. And I kind of think, when we think about the rationale for entrapment, it's that police shouldn't be tempting people into committing crimes and then, blaming them for it. We should have some right to go about our business without being faced with these sort of virtue testing. And with this, are you a good enough person to resist the police in terms of, secret police, secret undercover operations, and that kind of thing? Because quite frankly, a lot of people would be tempted. If you're talking about, if you go down onto the street somewhere, you find somebody who's working, a minimum wage job, and you say, hey, listen, we need a third person to go rob some place. There's going to be $100,000 in it for you. I'm betting that a lot of people might say, yeah, you know what, I'm in. But we don't do that. I mean, that's what entrapment is about, is to say, we can't do that. You can't give people these kinds of, tests just to see if they're a good enough person. That's not the kind of society we want to live in. We don't want to live in a society where we always have to be worried that the police are going to be coming by and sort of going, can we trick you into committing a crime? That's messed up. So, I mean, some of this stuff here is like, it's clear that the officer should never have been involved in it. But I mean, the other thing that I just keep thinking of when I go back to this is just that at no point does Constable Senior or, sort of go, what the heck? It's really kind of an indictment on that police force itself that this isn't something super obviously sketchy. That this is something where it's like, he's got these other officers saying, hey, can you get me steroids? And he's not going, what the heck? He's going, oh yeah, that's just Tuesday. So I kind of feel like, in terms of expressing their condemnation for a bad police officer, they kind of score a bit of an own goal here, that they kind of end up saying, listen, the culture is such that this never raised any alarms with this rookie officer, or with this officer. I don't know how much of a rookie he is. He's unfamiliar with these sort of informant investigations, but I don't know how many years he's got and so forth. But, that just kind of, eats away at the back of my mind. Like, what is going on at this police station if this isn't something that's super obviously either a setup or, yeah, if this fits in with the expectations of culture, it kind of raises worrying questions, I guess, is where I'll go with that. Anyway, this is a really wild case. It involves some really wild scenarios, some wild circumstances, and I'm really going to be looking forward to covering as well the entrapment argument, because I think that one is going to be fascinating. I'm trying to restrain myself from going into the law on entrapment here too much, because that's for a future video, and this one's going to be long. So let me know what you think of this one. Let me know what you think. I mean, I don't normally personally have a whole lot of sympathy for police officers who cross the line. I typically, typically my argument is that we should judge those officers more harshly than we do an ordinary person. If you're using the badge to commit crimes, that's worse than if you don't have the badge. Or if you're breaking your duties as an officer and by doing so committing a crime, that's kind of worse than if you weren't an officer, right? We have high expectations and high standards, or at least we should. But I do kind of have some sympathy for the guy. I mean, who could hold up to this scenario where everything around you is organized to try to get you to commit an offense? Your bosses are in on it, your partner is in on it. This guy who you think is a major informant and has become the focus probably of your career at this point, he's also in on it. Everything that's happening in his life is faked. It's kind of this Truman Show thing. And this is really kind of an example of them pulling a Mr. Big sting on the officer. And maybe I'll cover some Mr. Big stings in future videos. But anyway, I've probably rambled enough here. This will sort of conclude coverage of Mr. Senior, at least until we get the entrapment decision. But let me know what you think. I think this is a really complex and interesting story. And personally, the other thing I really like about this one is that the judge is very careful, very precise, very, there's no sort of temptation on the part of, I've been saying judge, it's a justice. I'm being a little overly casual here. There's no temptation on the part of the justice to just sort of say, oh yeah, he's guilty of everything. He's a bad person, guilty of everything. In fact, each charge is very carefully reasoned, and that is what we expect, and that is the norm in criminal cases. Lots of people were quite surprised when they saw in the news that Constable Senior had been convicted of some things and acquitted of others. But this is how the law should work, the careful application of legal tests to specific facts. And some of these legal issues are really thorny. When we look at the question of an attempt versus mere preparation, that's complicated. That's difficult. So I like this because it provides some insight and into how the court works. A lot of the time we just see news articles and they don't really tell us anything of the thought processes involved. To get that, we have to dive in. And I know that this is like a 6-hour now, epic, because it's almost 200 pages worth of content. And I've cut it down to as much as I could, the sort of raw elements. But anyway, I found this fascinating. I hope you guys have too. I know that these are some of my least successful videos in terms of viewership, but I kind of like doing them. It's taken me way too long to get this one out. Anyway, thank you for watching. I also want to thank my Patreon supporters at the $50 level: Jonathan Wheeler, Jason Elliott, Canada's National Farms Association, Mike, Kyle Martin, Jean-Guy Toussaint, CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Raymond L. McKinnon, Matt Ward, Mark Whittington, Jane Babe and Luxor, Dale Nesbitt, Cameron Johnson, Bruno R., and Andrew Elsich. Thank you as well to all of you at the $10 level who will be in the crawl immediately following. Thank you to everyone on Locals who's signed up. And thank you for watching. I hope this has armed you with knowledge. See you next time. I've got a whole bunch of things that I want to cover, including some really interesting... there's cases about firearm storage in vehicles. There's that So a couple of people have said, hey, can you do this case? I'm going to do the case. There's also some things on stun guns that I want to talk about. There's some news developments, lots of stuff that's sort of on the queue there. So keep watching. I'll be back soon, and till next time.